Good afternoon, good morning, good evening, depending on where you're receiving this broadcast from. Welcome to the third session of the ELS and AGA Africa webinar series. This particular session is on forensic evidence for lawyers. We have put together for you a team of experts that have excelled in this particular area. I will therefore like to thank you for taking your time to join us this afternoon. Without having to say much, my role here was to make the introductory remark and to thank you for coming on. I would like to welcome Norma from AGA Africa. Norma will make her opening remarks and then welcome Maggie Baingana, a member of the ELS Governing Council, who will officially open the session for us. So welcome, Norma.
Thank you very much, David. COVID-19 has sped up the use of technology. As law enforcement officers, it is our duty to keep up with digital trends and how best to gather evidence. Criminals are not taking a break, and neither should we. As we all know, at the core of our values as AGA Africa and EALS, we value the exchange of knowledge. This is our third webinar, as David mentioned, and we look forward to coming together on platforms like this one to better ourselves in such areas with digital forensics. Facilitators, AGA Africa reps, and EALS participants, welcome. I'd like to take this opportunity to tell you more about AGA Africa and what our goals are. As AGA Africa, we train investigators, prosecutors, judges, magistrates, and other law enforcement officers. We train them in the investigation and prosecution of transnational crimes. We also participate in seminars and other events to educate, increase public awareness, and draw attention to the dangers of transnational crimes. Our footprint is in 8 African countries, namely Ghana, Kenya, Malawi, Nairobi, Nigeria, Rwanda, South Africa, Uganda, and Zambia. Our journey does not end here. We are here today because you've been engaging with us on social media. Our handle is @AGA Africa. Once again, that handle is @AGA Africa. Thank you very much, and over to you, Madam Maggie.
Thank you so much, Norma, for those remarks. My name is Maggie Baingana. I'm from Rwanda, and I'm the treasurer for the East Africa Law Society. Ladies and gentlemen, on behalf of the Governing Council of the East Africa Law Society that I'll be calling ELS, I'm pleased to welcome you to this training event organized by our partnership between the East Africa Law Society and the Attorney General Alliance. This is the third event in a series of trainings we have rolled out to equip our members with tools for modern day legal practice. Thank you for finding time to join us today. I urge you to unlearn and relearn something today towards bettering your practice or careers. Without continuous retooling, the legal profession risks serious disruption. I wish to thank our partners, the Attorney General's Alliance Africa, for trusting us to be their partner and to provide a vehicle through which the legal profession in East Africa gets new skills. We have been partnering with AGA since 2017, and the fruits of the partnerships are now visible. Thank you, Mr. Marcus Green, and your entire team at AGA. We'll be holding another event in this series on Wednesday, the 22nd next week, where we'll be unpacking transnational crimes in the 21st century. Our institutional members, the law societies, have been part and parcel of these efforts at retooling the legal profession. I recognize the support given by the leadership of the Rwanda Bar Association, the Burundi Bar Association, South Sudan Bar Association, Uganda Law Society, Zanzibar Law Society, Tanganyika Law Society, and the Law Society of Kenya. I also recognize the dedication of our speakers for this event. They are drawn from amongst us and from the United States of America. Judge Sean Wallace of the Maryland 7th Circuit Court, Lawrence Dinger, a certified computer science forensic expert, Robert McKay, a distinguished lawyer in the field of law and technology, and our moderator, June Okal, who is a rising star in the area of law and technology. The combination of the skills and experience of the team facilitating us today are incredible, and we're very privileged to have them with us today. Ladies and gentlemen, this afternoon, you'll be learning about digital forensics. This field of law has been reshaped by use of technology for many years. Recent developments in technology have, however, dwarfed all the historical developments in the technology. The advent of computer and web-based communications have provided some of the greatest yet exciting challenges to the legal profession. The use of electronic evidence has been severely disrupted by the computer technology event. The digital footprints left behind when one uses modern technology is so vast, and yet lawyers must find a way to navigate them to defend or prosecute their interests, the interests of their clients. I recently followed the developments on cyber crime tracing involving Hushpuppi, the suspected dark web fraudster whose crimes were digitally traced using social media accounts. That piecemeal social media posts can be used to build a case involving hundreds of millions of US dollars is not only scary, but also underscores how important digital forensic is to our profession. Accounting fraud, business email compromise, and money laundering are now being fought using digital forensics. Complex crimes investigations, as well as commercial disputes investigations, are now enabled by digital forensics. Personally, I'm very excited to be here to learn just how impactful this phenomena is on our legal practice and profession. May I now take this opportunity to invite our guest and event sponsor, Mr. Marcus Green, to deliver his remarks. Marcus Green is a board member of the AGA, and we welcome you, sir. Thank you.
Thank you, Maggie. I'll just jump in. All right, thank you for the opening remarks from AGA Africa as well as the East African Law Society. Thank you, Norma, Maggie, and David. Good morning, good afternoon, good evening, wherever you are in the world. My name is June Okal, and I'll be your moderator for this session. So as has been earlier alluded to and spoken towards, the focus for our session today is digital forensics for lawyers. I'll give a brief structure of the outline of this webinar and the meeting, and then I'll proceed to introduce the presenters, and then the presenters will proceed and commence their presentations. So just to start, we have three presenters, three speakers, distinguished in their fields, experts with a wealth of experience to share. The agenda for today was to commence with the opening and the welcome remarks, which we have already had. So then we will move on to our first session, which is on the introduction to digital forensics, admissibility, and a practical view from the bench by Honorable Justice Sean Wallace. And then we will move to our second session, which is on the legal framework on digital forensics in East Africa, and analyze the practical matters that are important for lawyers to take into consideration in handling digital forensic evidence by Robert McKay. Then we'll have our last session, which is the analytical process for digital forensic evidence by Lawrence Dinga. After that, we will proceed into the Q&A session. For all our attendees, we will take the questions from the chat section. So on your panel, there is a chat option at the bottom where you're allowed to put in and submit your questions. We kindly request that as you put in your questions, you indicate which of the speakers you would like to best address it to. But I will take moderator's prerogative and also issue them in the event that you do not indicate who you'd prefer to respond to your question. Then we will finally have the closing remarks from AGA Africa. So I'll proceed to introduce our speakers, beginning with Honorable Justice Sean Wallace. So Justice Wallace is a judge of the circuit of the Circuit Court of the 7th Circuit of Maryland. He was appointed to the court in 2002, elected that year to a 15-year term, and in 2018 won election to another term. For most of his time on the bench, Judge Wallace has presided over complex civil litigation, including business and commercial disputes, in addition to major criminal prosecution. He has also been designated to sit on the Maryland Court of Special Appeals. Judge Wallace is a founding member of the American College of Business Court Judges, that is the ACBCJ, and was president in 2013 to 2014. He also served as a business court representative to the business law section of the American Bar Association from 2010 to 2012. He served as vice chairman of the Business and Commercial Courts Committee of the National Conference of State Trial Judges in 2006 to 2007. He additionally chairs the Maryland Judiciary Subcommittee on Business and Technology Case Management. Judge Wallace was elected as an inaugural fellow of the Advanced Science and Technology Adjudication Resource Center, that is ASTAR, in 2006. He has served on the Judicial Advisory Board for the Law and Economics Center of George Mason University, Scalia Law School, for the past 8 years. He has lectured frequently on various legal topics, including to the International Judicial Academy, the Practicing Law Institute in New York City, and Georgetown University Law Center CLE programs. He's also lectured at the Judicial Institute of Maryland, the ACBCJ, and the Maryland New Trial Judges Orientation. Judge Wallace was on the adjunct faculty of the National College of District Attorneys, lecturing regularly across the country from the period of 2002 to 2006. Prior to his appointment to the bench, Judge Wallace was county attorney and represented the county before federal and state trial and appellate courts. He was also in private practice for a number of years, focused mainly on federal and state litigation. He received his Juris Doctor degree from the University of Maryland School of Law in 1985 and his undergraduate degree from Hampton-Sydney College in 1982. In 2001, he was resident in the Harvard University Program for Senior Executives in State and Local Government. Judge Wallace has been admitted to practice in the courts of Maryland and the District of Columbia, as well as many federal courts at both the trial and appellate levels. He served on the Board of Governors of the Maryland State Bar Association from 2003 to 2005 and was president of the Prince George's County Bar Association the prior year. He served 16 years on the Maryland Attorney Grievance Commission Peer Review Committee before ascending to the bench. Judge Wallace also has been active in the Digs Inn of Courts between 1986 to 1988 and the Southern Maryland Inn of Courts from 2011 to present. Wow. Distinguished, as you can tell. So I'll hand it over to Judge Wallace to proceed with your presentation. Thank you. Sorry, Judge, you're still on mute.
There we
Hello,
are.
Judge, we still can't hear you. Oh, we can hear you now.
Yes, I was muted. Thank you, June, for that very thorough and kind introduction. You left out a few things: my height, my weight, and most importantly, that I am the father of 2 teenagers, which gives me a lot of practical information relating to electronic evidence. So without further ado, let me share my screen and let's see if we can. Can everybody see that?
Yes, we can.
All right. So I'm going to talk a little bit, kind of give a primer of the sources and admissibility of electronic evidence. So what is electronic evidence? And let me move this. There we are. Electronic evidence is data that is collected and stored electronically. So that includes emails, text messages, video files, instant messages or IMs, audio files, anything, frankly, that can be found in computers, and anything that uses computer technology can be the source of electronic evidence. Some of those things, most obviously, cell phones, video gaming consoles, key cards to hotels and other places, vehicles, credit cards, doorbells now, watches, if you have a smartwatch, cameras, even plain boarding passes. So how does cell phone evidence, which is the most common evidence that I see in my courtroom, electronic evidence, how does it work? Well, the phone company keeps phone records for the purposes of billing, network testing, customer service, and support, most importantly, billing. And they're kept in their own company fashion. So you may see cell phone records from different companies that look differently. And just a couple of the definitional phrases that we'll use here today. Switch is a large geographic area covered by cell phone technology. A cell site is the physical tower to which it's connected. We call them towers here, but I understand that they're frequently called masts in your area of the world. And then the towers have sides, and we'll talk about that in just a minute. And the side is the tower, the side of the tower that is used. Where is the connection coming from? What is the angle of the tower toward the ground? And so what happens with cell phones is the cell service network has one or two bands of frequency that's divided into channels. And when a phone is turned on, it scans those bands and tries to find a channel with the strongest signal. And that will, of course, depend on the location of the towers or masts. So these are different types of cell sites that we see in the United States. Several of them, looks somewhat like a cross. This looks like a palm tree. These are common on buildings in urban areas. This is also a more common one that we're seeing now. These were common in more rural areas, but they are disappearing to some extent. These all through here, this also is one disguised as a tree. This one in our southwest portion of the United States disguised as a cactus tree. And this one I suspect that you do not see often in your area of the world looks somewhat like this, but it's covered with snow and ice. So the distance between these towers or masts, whatever they look like, varies with the environment. In rural areas, they can be up to 8 to 12 kilometers in radius between them, distance. In urban areas where there are obstructions and many subscribers using these masts or towers, they can be as close as 800 meters or even less. So what happens is the cell phone, as I told you, a tower has three sides, 1, 2, 3 here, and each side has an antenna, and each antenna covers 120 degrees of coverage. Actually, it's usually 130 degrees to allow for slight overlap at either end, but for our purposes, we say it's 120 degrees. The direction that the antenna points. So this antenna here points in this direction. This would be called the azimuth, A-Z-I-M-U-T-H. So there's one here, there's an antenna here, and the azimuth is this direction, an antenna here, and the azimuth is this direction. And these are generally at 60, 180, and 300 degrees on a compass. These are the azimuths. And you'll see that 60, 180, and 300 is adding 120 degrees to each one. And what happens is the towers ping the nearby phones and say, basically, here I am. I'm available to take your call. And the phone responds electronically with something to the effect of, okay, I see you, thank you. And they do that, and in do so, they connect with each other so that they are available. That connection is available when they are making or receiving a call. The phones connect, as I've said, to the strongest signal, which usually is the closest, but not always. So what we call that is the closest available signal. It's usually the closest tower because that's going to be the strongest, but there may be an obstruction, or if there are a number of subscribers using that particular tower at that moment, then that's not available, and it'll go to an adjoining tower. And you'll see that what happens, towers and masts are set up with this overlap as well. So each one of these triangles represents a mast or a tower, a cell site. This is the coverage from that tower. And then each one of these reflects an antenna, red, blue, and green. The azimuth is the arrow. And you'll see how, therefore, they overlap, but they're generally, this one is covering this direction, this one's covering this direction. All right, so that's how the basic technology works. So what kind of information can be obtained regarding this technology? Well, of course, you can get the account information, who's the user and subscriber, the billing information, their address, etc. You can get the call detail records, and that's most of what we're going to be talking about. The tower information is related to this, cell site activation and the cell tower locations. Often you'll get the address and alternate phone numbers for the subscriber, and you'll get information as to when the phone is transmitting data. So what happens is, I told you, phone companies, they bill for their phone service, and they keep records in order to generate these bills, to support the bills if someone questions whether they should have been charged, and to improve their network capacity. If they see that there are problems with the network from these records, they may say, we need to install another cell site, another tower or mast in order to do that. So most location data relies on the cell tower information. You can also obtain from many phone companies their internet and email usage, data usage, whether there were stored emails, depends on the company and the phone. Text messages, the same, depends. GPS tracking, which is in real time, and we'll talk more about that in a moment, and photos and videos that may be installed on the phone. So this is what a typical presentation of cell site data by the prosecution in my courtroom looks like. They will have subpoenaed the data from the phone company, and they will get something like this chart at the top. Has the date and the time, the duration of the call, the tower, and these are numbers. Each tower has a separate series of numbers, the latitude and longitude where that tower is located, and the azimuth. You'll see that these are 195. I told you that they may be 180 for an example, but 195 is the direction that this particular tower is located. This shows, with these red dots, all the towers that are available in the area. This one with the little tail is the one that was being activated. This is tower 161, 277, 2. And the little tail kind of points, I'm sorry, it's this one. The little tail points in the direction of the azimuth, the tower and the antenna that was being used. This other one with the label on it, that is a key location for that case. That was important to that case, and they wanted to relate the cell tower to the location. So you'll see that then a few minutes later, that cell phone is no longer hitting on this tower, it's hitting on this tower and in this direction. And that tells you that it's likely moved, or for some reason, this tower is no longer available. And because it is just after midnight, it's unlikely that this became suddenly oversubscribed. So what it means is that that phone has moved from this general area to this general area. And then this, you see, is a larger view, many more sites, mass sites, and it's moved from this location here, where it was, to this location. This is 2 hours later. And so now it's in this area here somewhere. And we know that in all likelihood, this being the strongest, it's closer to this masked site than to this one or this one, but it is in this area somewhere. All right. So that's generally what we'll see in my courtroom when the prosecution presents that evidence. So this technology and the data can show the general location of a known cell phone within the limits of the azimuth area, this that we know it's in this kind of third, and the tower distances. So we know that generally it's going to be in this portion rather than this portion, because it would be hitting from this tower if that were available. Now, other technology can provide more detailed location information. That technology includes GPS, Bluetooth, and Wi-Fi. Unlike using cell site data, GPS triangulates signals from dozens of satellites that are flying overhead, perhaps 2,000 kilometers above us. However, this GPS data is accurate within at least, and sometimes they say less than 5 meters under an open sky. So that's the designation. If you were in the middle of the desert, open sky, no obstructions, it could be accurate to perhaps 4.9 or even closer in location. The accuracy drops as the signal it encounters blockages and reflections, which are more common in an urban area. So under an open sky, 5 meters or less, under in an urban area, the accuracy is not quite as good. So that's GPS technology. And where is that used in my courtroom? I'm sorry, in geofencing. So suppose the person and their cell phone is not known to law enforcement. There was a crime in a certain area. They don't know who committed this crime. They don't have a suspect. So they want to find out who may have been in that area. So they use geofencing technology. Now, geofencing technology is location-based. It comes from location-based marketing strategy, commercial marketing strategy, to determine when a target customer enters an area set by boundaries. So companies want to use location in order to send ads and push notifications to people that are on those phones in that area. So that is often accurate within 100 to 200 meters in an urban environment. So what happens is the law enforcement says, well, there was a robbery, let's say, for example, in a particular location, and we want to find out all the phones that were operating at around that time in that general location. So they send out a warrant like this one, and the warrant includes often a map, and this is a Google map, and you'll see that this was the location of the robbery. And so they've marked out, we would like to have all of the phones that were in operation at that particular time within this boundary. And so that's the warrant. You'll see that this is a longitude, latitude description of what's here. And that will generate a list of phones in that specific area at that specific time. This information is obtained by the government via a warrant based on probable cause, but it's commercially available to anyone for a fee. That's why these companies are in this business. Location data industry, the industry is huge. At last time I checked, there were over 7,000 companies, including Google Maps, that had 1 billion users active every month. Smaller apps also are in this industry, and they insert tracking programs into their apps via software development kits or SDKs. They get that data and then they sell that data to larger companies, often for pennies. So you could buy for 2 Kenyan shillings, you could buy perhaps 10,000 users' data as to where their location was. Those larger companies use that data to fuel analysis, like measuring whether people visit a store after seeing an online ad. That, of course, is the commercial purpose for this technology. Or helping marketers build more detailed profiles about people for targeted ads, okay? One example that I have read about is a weather app called My Radar, and that when in the test they used, it sent precise location data to a larger company, Cubic, 20 times during an 8-minute walk. Somebody's walking for 8 minutes, and 20 times during that 8 minutes, the My Radar weather app updated their location and sent that data to a large aggregator. Another one that's very familiar, not to me personally, but the story is familiar. There's a beer app, and it was called Untapped, and it was used to supposedly connect beer aficionados, tell them about particularly good or unique beer and where it can be found. That beer app, Untapped, was used to track military and intelligence users, people at the CIA, for example, when they were at work and after work, including the bars that they frequent and the most popular beers at those bars. So obviously, some people are concerned about, could a foreign country send an agent to a bar where many CIA agents go after work, know what the popular beer is there, go in there and start talking about the popular beer, ingratiate themselves, and thus try to make some inroads. This same technology was used about 6 months ago, was analyzed by the New York Times in an article that tracked different people. So this was a Secret Service agent, and this is in Washington, D.C. There's the White House, the Capitol, our legislative branch, the Pentagon, where our military is. And these green lines all reflect the routes that one Secret Service agent took that day. Secret Service agent, of course, is someone who is sworn to protect the president or other high officials. So that's one example. This was a second Secret Service agent for a day, tracking his or her movements. A staffer at the Supreme Court. The Supreme Court is located near our Capitol. A Department of Defense official. You see there's more activity around the Pentagon where they would have been done. Director for the House of Representatives Committee here closer to the Capitol, and for an advisor for a United States Senator. So all that was available to the New York Times because they paid a fee, and they generated this session, or this information from publicly available information, commercially available. COVID has grown this industry with social distancing apps. So here are 4 social distancing apps. These were listed in a New Delhi, India website. Aragoya Setu here, 1.5, which was developed by the United Nations, 1.5 being the meters, the distance they want you to, people keep your distance. My Shield was another one, and M-Contain, yet another. These are all use Bluetooth technology to locate people. And ultimately, this one, Aragoya Setu, was developed. It was developed by the Indian government and the Indian government made it mandatory for all employees, whether private or public, to download and keep on this app as India began to reopen in about April, late April, early May of this year. They all use Bluetooth technology. In addition to these four, there are many others, and Taiwan and Israel are very well known for widespread government use of location technology regarding the pandemic. Okay, so that's GPS. Let me talk a little bit about another aspect of, I'll give you a case example, another aspect of electronic evidence in my courtroom. What happened in this case is a woman awoke alone in a strange hotel room with no memory of how she got there. She went to the front desk and said, "Where am I? How did I get here?" The person said, "Well, this is how somebody checked you in." She was taken to the hospital for a sexual assault exam, which revealed DNA from a male contributor in her body. She had been on a dinner date the night before. She called her dinner date and said, "How did I get here? Did you bring me to this hotel?" And he said, "No, I put you in an Uber to take you home." And so he sent her the receipt for the Uber. The police then subpoenaed Uber for their records. This is the response. This is a letter to a detective, Detective Jameson Spicer, in response to the search warrant that was issued. And this is the information they got. Rider information associated with the trip, the name, Charles Mabaka. This was the date. So he was the user who had ordered the ride. The driver, Westang Pierre, and his information, his phone number, the vehicle, license plate, etc., and a copy of the trip receipts and a copy of detailed GPS. So that was all provided. These are just definitions that they use in their letter. And this is a copy of the receipt. So it shows a ride from Washington, D.C. to Fairfax, Virginia, her home, where she lived. This is where they were on the date. This is her home. It shows the time, the beginning time, the ending time, the cost, $20. You saved $19.64 by riding Uber Pool. That will become interesting in a moment. So it also showed the prior other rides that this driver had. You rode with Westang Pierre. And as I said, there was an Uber Pool. They sent the information for the Uber Pool. Uber Pool means that the driver can pick up another fare along the way and take them. So you can share the Uber car ride and drop somebody up, pick somebody up on the way, drop them off on the way. In this case, it did stop for two other women at a bar called the Elephant and Castle. One of those women came in to testify. She said, we ordered an Uber, the Uber pulled up, it matched, it had the same license plate and description of the car. I looked at the driver and his picture was the same as what the driver was there. But we turned down the ride because we saw a woman passed out in the back seat and we were afraid that she was drunk and would vomit on us. So we turned down the ride. They only got a $2 fee for the driver going there and then turning down the ride. Now the driver had taken the victim to her house and dropped her off, and then he turned off the Uber app, meaning that he wasn't available, showing as being available to pick up further fares or further rides. However, the app kept his GPS location open. And so all this information, the GPS location, again, longitude and latitude this way, was available. And based on that, they could say, this is where she was picked up. This is the Elephant and Castle bar, the second stop where the women were offered a ride and chose not to. This is her home. And they show, let me see if I can do this here, that by following that, they went from here to here. They went over and this route, following Route 66, a major highway, to her house. He got to her house. He stopped and turned off his app, but she was still passed out. He kept her in the car. He then drove back along this route, and then he drove all the way up in this direction, all the way around until here where the hotel was. All told, he drove about 84 kilometers from her home to this hotel. He passed then from the jurisdiction of Washington, D.C. into the state of Virginia, left Virginia, went into the state of Maryland, where I sit, and into my jurisdiction, which covers all this east side of Washington, D.C. So it showed that he did there. He went there. Let me just erase this. And then another bit of electronic technology that was used was there was a surveillance camera at the hotel. And let me see if I can get this to play for us here. I'm going to turn this off. No. How unfortunate. We were successful yesterday when we practiced this. This is his car, and the video would show him getting out and carrying the limp body of the victim over his shoulder like a sack of vegetables through here and into a hotel room, coming back out, locking his car, and then going back into the room. So that too is digital evidence. Between the Uber evidence that showed him picking her up, the route he took to her house, the GPS taking her all the way around, and then this evidence, it placed him and her in that hotel room. His DNA confirmed that he had in her body, confirmed that he had intercourse with her. And this video that I really wish we could had better luck showing would demonstrate that she was completely passed out. And so it negated his defense, the only defense he had when his DNA was found, that this intercourse had been consensual. Therefore, this electronic evidence convicted him of second-degree rape, and he received the jury convicted him. We have juries in the United States for these kind of cases, and I sentenced him to 20 years incarceration. Now, let me briefly touch on one more case. Is digital evidence admissible? There was a case in my state Supreme Court, Griffin versus State. The defendant was on trial in connection with a shooting death at a local bar. The prosecutor offered evidence from a MySpace account. This will tell you how long ago this was, but MySpace, that was purportedly held by the defendant, Griffin's girlfriend, Jessica Banker. The profile was under the name Sister Soldier. It described the owner of the profile as a 23-year-old female from the area, lived in that area of the bar, showed a birthday of 10/23/1983, which was Jessica Banker's birthday, and contained a photograph of the embracing couple, that is Ms. Banker and Mr. Griffin. So there was a particular post that said "Free Boozy." Boozy was Mr. Griffin's nickname. Free Boozy, just remember, snitches get stitches. You know who you are. For obvious reasons, the prosecution wanted to present that evidence. At the trial, a police sergeant testified that he knew the Sister Soldier profile was hers through the photograph of her and Boozy, the defendant, on the front, through references to Boozy, the defendant, references to the children they shared, her birthday, and he knew that she was his live-in fiance. He was convicted, and it went to the Supreme Court. They held that the trial judge abused his discretion by admitting this evidence since he failed to acknowledge the possibility or likelihood that another user could have created the profile in issue or authored the snitches get stitches posting. That was the Supreme Court ruling. They went on to suggest ways it could have been authenticated, saying they could have had her come in and say it was her profile and she posted it. That was, of course, very unlikely. They could have seized her computer and had that searched to determine whether it had created the profile and the posting. Again, quite unlikely. Or they could have had a witness from MySpace come in and testify about the information that links the profile and the posting to the girlfriend. Again, that would be a tremendous burden to bring in a witness from MySpace, or think now of Facebook, to testify on every one of these cases. 2 judges on our Supreme Court dissented from that decision, accusing the majority of the technological heebie-jeebies. Heebie-jeebies is a phrase in the United States meaning a state of nervous anxiety. They said, you have the technological heebie-jeebies. The concerns that you raised go to the weight to be given to the evidence by the jury or the fact finder, and not to whether it's admissible. Legal commentators made the same criticism, and just a few years later, the Supreme Court reversed it. Well, I say they reversed themselves. They say they just clarified their ruling to say that they were wrong. So the lesson that I have for you all is to avoid the technological heebie-jeebies. Remember that the same rules of evidence apply generally to digital evidence. It's in a different form, but the same rules generally apply: authentication, hearsay, etc. And that is how we deal with electronic evidence in my courtroom. And I am now going to turn it back over to June, and I will see if I can stop sharing.
Thank you, Judge Wallace. That was very insightful. Working for a tower company, it's actually quite insightful to just understand how whatever information bounces off our infrastructure can be used for evidence purposes. I'll ask Robert to start setting up as we jump into our next presentation. So, adding on to where Judge Wallace has left with regards to the practical issues and elements that lawyers and judges need to consider in handling digital forensics, we will move to our second session, which is the legal framework on digital forensics in East Africa, with a focus on the practical matters that are important for lawyers in handling digital forensic evidence. I'll introduce you to our speaker, Robert McKay. Robert McKay is a practicing advocate. Thank you, Robert. We can see your screen. Robert McKay is a practicing advocate at R. McKay Advocates. He's a partner there, and the firm is based in Kampala, Uganda, where he represents businesses and individuals facing criminal investigation and prosecution. Mr. McKay is also a head of subject at the Law Development Center, Department of Postgraduate Legal Studies and Legal Aid, which is the bar course in Uganda. Mr. McKay received his Bachelor of Laws from Makerere University and holds a Master's in International Crime and Justice from the University of Turin and the United Nations Interregional Crime and Justice Research Institute, UNICRI, in Italy. He has also undertaken several specialized trainings in his field of practice, including success prosecutions of counterterrorism cases, the International Institute for Justice and the Rule of Law, that's the IIJ in Malta. He's also taken training on cases related to financial crime, money laundering, and terrorism financing, patterns and legal issues, the Sakasa International Institute for Criminal Justice and Human Rights in Italy, anti-corruption corporate compliance in oil and gas in Texas, USA, combating crime by the Royal Institute of Public Administration in London, doing business with multilateral development banks from the Washington College of Law under the American University in the US, US and International Anti-Corruption Law Program from the Washington College of Law, and has a diploma in International Commercial Arbitration from the American University. He has experience with more than 10 years criminal litigation in the office of the DPP, or the Director of Public Prosecutions, particularly in the Anti-Corruption Division. And that experience benefits his clients, who are businesses, corporate officers, and employees, and other individuals involved in white-collar criminal investigations and prosecutions. He also represents in matters pertaining to civil litigation and administrative proceedings. He has also represented businesses and individuals who are victims of economic crime in the interactions with law enforcement agencies and prosecutors. He perused and sanctioned several dozens of criminal cases while serving as prosecutor with the Office of the Director of Public Prosecution, the Anti-Corruption Division, Kololo, prior to his position at R. McKay Advocates. Mr. McKay has briefed and argued many cases before the Anti-Corruption Division of the High Court in Kololo and filed briefs in other appellate courts, including successful plea bargain agreements for an international company and local clients. As stated earlier, he is a member of the White Collar Defense and Investigations Practice Group, the Anti-Corruption Committee in the International Bar Association, the Association of Defense Counsel, ICC, and the Criminal Cluster, the Uganda Law Society and the East African Law Society. His practice focuses on white collar criminal defense, internal investigations, and corporate compliance. Robert, over to you.
Thank you, June, for your kind words of introduction. I've been warned I have 25 minutes within which to make the presentation, and I'll right away go to the introduction. Now,
sorry, Robert,
lawyers,
please maximize your screen and present in slideshow.
Okay. Yes. As lawyers, what do we need to know about digital forensics? If you are representing a client, what must you attack if you are from the side of the defense, where prosecution has adduced evidence purely relying on digital evidence? Are we going to continue relying on the other old fashion of the best evidence rule that you must bring the physical document in court? If you don't have a physical document, then likely to raise an objection. That is not the position of the law as we talk now. In 2000, African Union came up with a convention, African Union Convention on Cyber Security and Personal Data Protection. Now, the purpose of that law was to ensure that digital evidence is enacted in most parts of the East African community because there was a rising level of transnational crime purely committed by way of computer crimes. Now, it is important for lawyers to be aware of the distinctive characteristics of digital evidence to enable them confidently and reliably to assess the evidential weight of proof by the digital methods. How did Uganda react and East Africa in general with regard to the African Union Convention on Cyber Security and Personal Data Protection? Now, Uganda in 2010, like any East African country, introduced the following new legal laws specific to digital evidence. They enacted, for example, in my country, the Computer Misuse Act 2010, Regulation of Interception of Communications Act 2010, Electronic Transactions Act 2011, Electronic Signatures Act 2011, Data Protection and Privacy Act 2019, of course, following an African Union Convention on Cybersecurity and Data of 2000. Now, what was the purpose and the rationale of enacting these laws? What were the legal impediments that were going to be faced by any practitioner, be it an attorney in private practice, be it a prosecutor from either the Office of the Director of Public Prosecutions or any other organization that has prosecutorial powers? Now, the purpose of these acts were introduced to remove the legal impediments to the recognition of electronic documents and digital signatures as a means of legal requirements for documents to be in writing and signed. Meaning that if a prosecutor was going to adduce evidence by way of digital form, you had no right as a defense attorney to argue and say, my lord, this evidence is not in the primary form. This evidence has been copied and transmitted onto another medium, and therefore it should not be admitted. The African Union had in mind that it was not going to be business as usual by enacting these laws, meaning that any digital signatures, any document that is in a digital form was to be allowed as long as it passed the test that the Judge Wallace has told us. Is it authentic? Is it admissible? Has it gone through that process that can secure its integrity? Now, having come up with that legal framework, it meant that the work for prosecutors, the work for in-house lawyers, the work for these other corporate lawyers that were looking at these criminals who had either hacked into a bank system or had defrauded somebody from any space in the world would be admitted in court. But then, how was that evidence to be admitted in court in respect of those enactments that had been done? Because you do realize that there are very few experts who can be able to tender that evidence in an electronic form, so much so that it is admissible before any courts of law. It became necessary that there was a need for experts in electronic discovery so as to ensure that all those legal processes were properly reviewed and then the documents are admitted. Now, I have some of what I think a legal practitioner should know in terms of digital evidence and computer forensics. I'll just go to Judge Wallace has tackled that requirements of digital evidence under those laws that I have highlighted, which cut across Uganda, Kenya, Rwanda, Burundi, and then now South Sudan, which is part of the East African community. Now, the first hurdle that any person that is trying to rely on digital evidence, you must, first of all, prove that it is admissible. Is it compliant with the law and the best practices? Is it authentic? Is it reliable and believable? And have you respected the human rights of the suspect that you want to prosecute via digital evidence? How is it found? The laws that I've already embarked on will give you that digital evidence can either be in a camera or other forms. Judge Wallace has talked about that one, how digital evidence is found. I don't need to go on that. Now, digital evidence is complex in nature. Now, I'll first give you this example of this case that was handled. I know that you must know about it. Gentleman was later reached because process not been followed. Julia Amero is a supply teacher at the Kelly School in Norwich, showing pornography to children under the age of 16. Now, what happened? This is how the trial began. 19th of October 2004, inappropriate pictures are found on his. Police looks at the content of the hard disk, but does not take a bitstream copy. I'll talk about what it means to have a bitstream copy for purposes of authenticating digital evidence. Of course, on 20th of October 2004, the regular teacher comes into a classroom, sees that the cache contains phonographic files, and informs the headmaster. Court finds Julia guilty of impairing the morals of children. Now, what did the defense team do? The defense team protested, and I'm sorry about that. The defense team protested and requested a new trial on the grounds that the evidence was not acquired correctly and that the computer was infected at that particular time, which was granted. A new trial was obtained, and then Julia was fined, imagine, only $100 for that crime. In Uganda, I happened to handle one case, which of course you'll see in the slides. It was involving the Inspectorate of Government, where they had used a spy key ring for purposes of investigating their own staff who was alleged to have obtained a bribe. Now, that spy key ring was given to the complainant to go and record the person who was demanding for a bribe of $150,000 US. Now, this complainant goes and uses the spy key ring to obtain the evidence. Now, the investigators messed with one step. It was agreed between them and the complainant that every time she does record the suspect, she's supposed to return this spy key ring to the investigators so that they can do what we call bit streaming for purposes of copying onto the computer. Now, what happened in that case, which I personally handled, when we came to analyze that piece of evidence, we discovered that the timestamp and the date stamp were not tallying, meaning that there had been an alteration in the process of bit streaming of that crucial evidence. We raised an objection that no, that document, that evidence was not authentic, and as far as it had been altered, it had been modified for purposes of bringing our client to a conviction, which shouldn't be. The trial court agreed with us, and our client was acquitted for failure to follow the key steps in how digital evidence should be secured and stored. There was an appeal by the prosecution. The appellate court overturned the decision of the lower court, arguing that without even the digital evidence, there was other evidence that could be used by the judge at that particular time to convict our client, meaning our client now was convicted by the first appellate court. We appealed on a point of law and said that no, court did not evaluate the evidence in a proper manner, because had it done so, it would have discovered that the prosecution case solely relied or depended on that digital evidence. Without that digital evidence, the evidence of solicitation, the evidence of receipt of the bribe could not be available. And the appellate court agreed with us and restored the decision of the trial court. Then the second matter that we also argued, why am I bringing this? I want the legal practitioners to be very, very careful when they are dealing with digital evidence. It's not business as usual. You must sit down. You must look at your experts, go through the evidence that the prosecution is giving you, and see to it that you can raise a reasonable doubt, which is your duty as a defense attorney. Another matter also involved digital evidence. It's related to integrated financial management system in the office of the Prime Minister, where funds had been stolen by an accountant and then allegedly wired on my client's account, who was a signer. They adduced digital evidence to show that there was a movement of funds from Bank of Uganda to my client's account. Now, when we analyzed that evidence, we discovered that this evidence was not properly secured. How did we discover? For example, a payment that had left Bank of Uganda, let's say on the 15th day of July 2020, had arrived at my client's account on the 12th day of July 2020. It couldn't have been possible. We argued that where there is a credit entry, there must be a corresponding debit entry. Therefore, money couldn't have left BOU, Bank of Uganda, to a client's account before it left. Now, we later discovered that there was tampering and alteration of the digital evidence, and during that alteration, they forgot to change the date stamp and the time stamp. The trial court convicted our client. We appealed on a point of law and said, look, if you look at this evidence, the way it is assembled, there is no way money could have left even before the integrated financial management system button had been pressed. It wasn't possible. It wasn't possible. And the appellate court agreed with us, and our client was acquitted. Now, I'll take you to this example on the slide of another matter where you can raise what we call IT alibi. How can you say it wasn't me, it wasn't my client, when you are relying on the evidence of just a minute. The computer seems to be freezing. Just a minute. Yes. Now, I'll take you to the Italian case. Alberto was charged with murder of his girlfriend. Evidence was read by the prosecution to show that Alberto and the wife were in the apartment at the material time. When it came to the trial, the defense attorney raised a PO to the extent that Chiara Poggi died between 10:30 p.m. and 12 a.m. The accused handed over his PC to the police. All his telephones were handed over to police for purposes of digital forensic. And it was discovered that by the time of the alleged murder, the accused person was working on his service during the period when the girlfriend was killed. What could have gone wrong was the question. Because Thasi was acquitted of murder, relying on IT alibi. Could it be the case that there was an alteration, there was a modification in the way this evidence was assembled and stored by the investigators? Of course, your guess is as good as mine. Now, I'll not go into that. I'll take you to what we need to know as attorneys when we are handling cases involving digital evidence. How do you challenge this evidence to ensure that you get your client off the hook? If you are the investigator, what must you put in place to ensure that you get justice for either the bank, any other institution that has been prone to that kind of cyber crime. There are numerous errors which may arise that may make the evidence that has been assembled by the prosecution to be discredited. What may cause that? And you as the defense attorney, what kind of questions must you put across to ensure that you bring it to the attention of the judge that this evidence that the prosecution is trying to rely on may not be the best evidence as they assume? Has that evidence been corrupted? Has there been loss of data? Has there been interference with the data and errors in the interpretation and the analysis of the evidence? Of course, this is not to say that the system deliberately corrupts data, although the introduction of, as my colleague will be telling you, Trojan horse or other form of malicious software may cause data to be corrupted. Now, you as counsel, what must you do? What kind of questions must you ask in order to ensure that your client gets off the hook? And these are the questions that I put here that you must have at the back of your mind. First and foremost, there are two fundamental principles in relation to copying digital evidence that a digital evidence specialist should be aware of. The process of making the image should not alter the original evidence. As I told you in the matter which I handled of a spy hearing, that is what happened. And indeed, you could see the face of our client into the video that had been recorded. But we said no, the time stamp, the date stamp did not matter, did not match with the particulars of the crime. This means that the appropriate steps should be taken to ensure that the process used to take the image should not write any data to the original medium. Two, the process of copying data should produce an exact copy of the original, meaning that such a reproduction should allow the specialist to investigate the files in the way they had existed on the original medium. My colleague and I will talk about how a hash process is relied on for checking authenticity, veracity of the file after they have been copied. Now, these are the key questions to ask the practitioners, which we must know, especially when we are dealing with that particular witness that is coming to testify, either for an institution, either for prosecution. What types of digital evidence can be collected prior to the involvement of the law enforcement officer? For example, in a cyber stalking case, does a hard copy version of the email exist? Does it contain full header information? Because you are trying to tell this court that it is the accused person who committed that crime. Secondly, who handled the evidence? Document the name and job function of each individual who handled the digital evidence. Be aware that more than one person could be involved in this process. Now, as a cross-examiner, are you going to cross-examine this particular expert along that line? As an investigator, are you going to follow these guidelines? Identify everyone who had control of the digital evidence after it was examined and before it was given to law enforcement. Because integrity, authenticity of the digital evidence, like any other evidence, is of paramount importance. How was the digital evidence collected and stored? Are you going to break the chain of custody of the evidence? And how do you determine who had access to the digital evidence after it was collected? When was the evidence collected? Document the date and time when the evidence was gathered. Because even if you are relying on the Electronic Transactions Act, Electronic Signatures Act, Computer Misuse Act, which give you a leeway to assemble this evidence in a digital form, it doesn't take away the authenticity rule that must be prevalent. Now, is it true that you waited until 3 days after receiving the computer to book it into a secure room? Where was the evidence when it was collected? What kind of device held the digital evidence? Is a serial number present? Who had access to the device? Who owned that device? Was the device shared? Was information retrieved from a network? Judge Wallace has taken us through how those networks work. Was the information password protected? Who had access to the password protected information? Like in that matter of the office of the Prime Minister, money could only move by a press of button through the IFMS system because it was password controlled. And the person who was accused of stealing the money was not the person in the dock, and no evidence was adduced that it had been hacked into. Is the data located at an offshore site location? Sorry about that. Now, yes. Now, you do realize that whenever we are dealing with digital evidence, there will always be a specialist who will set out his investigation in form of a report. Whether prepared for criminal or civil proceedings, you as a legal practitioner, you need to take note of the following, which may help you either to present the evidence or to cross-examine the person who is presenting that digital evidence. Where are the notes that were prepared during the examination phase of the investigations? Where are the details about the way in which investigations was conducted? Chain of custody. What was discovered, including but not limited to the following: any specific files, data that may support the conclusions reached by the specialist. This will include the recovery of any deleted files and analysis of any graphic files. Because when you look at that legal regime that we have given you, even if the file has been deleted and the specialist has recovered it, you as counsel on the opposite side will not stand up to object and say, no, this is secondary evidence, because the legal impediment has been removed by that legislation that has been enacted. Any further specific files or data that were directly related to the investigations, are they there? Types of searches conducted. Remember, we have the Data Protection Act that guarantees the suspect of his right to privacy, which is constitutionally guaranteed, except where there is a crime that is being investigated. And there is a court order that is allowing you to either intercept phone calls, especially in this era of terrorism, or in cyber crimes. Any relevant evidence from the internet, such as emails and analysis of the websites visited and log files, must be indicated. I'm sorry I had to go through the way I have done because I did not want to take most of your time, and I thank you so much for listening to me. Thank you.
Thank you, Robert. That was very insightful. Just a reminder for the attendees that questions are being taken on the chat box. So kindly, you can still put up your question, but then kindly indicate who you'd like to address that to. As I introduce Lawrence, Lawrence, please start preparing your screen to share as we proceed to the third session. So the next session is the analytical processes that are taken into consideration and undertaken for digital forensic evidence. Thank you. We can see your screen, but it's on Gmail. So Lawrence is our next presenter. He's a cybersecurity and digital forensic specialist at ManageCom Systems Limited. Lawrence is an accomplished cybersecurity and digital forensic specialist, where he is the founder and the CEO of ManageCom Systems. He is tasked with a strategic leadership role to steer the company down the right path for success. at managed com systems, they understand that people are the greatest asset and also the biggest vulnerability within an organization. Lawrence comes equipped with a wealth of experience and expertise in cyber capacity building, both at the technical and professional level. He trains the technical audience in certified cybersecurity courses such as CISSP and CISM, as well as incident response, digital forensics, critical infrastructure protection, and industrial control system security. He also trains and evangelizes cybersecurity awareness among professionals, including lawyers, prosecutors, magistrates, and judges in areas of cybercrime, electronic evidence, and digital forensics. Lawrence holds a master's in forensic computing and security from the University of Derby in England, an LLM in ICT law from the Open University of Tanzania, and a diploma in law from the Kenya School of Law. He's also a holder of the much coveted ICS² CISS, which is Certified Information Systems Security Professional, CISSP. Lawrence has extensive IT consultancy and cyber capacity building experience in the EMEA region, and is also a co-founder and director of WTech Africa, that is a leading cybersecurity and digital forensics consulting services provider in Africa. Currently, Lawrence is working on a proposal to the NC3 for the review of the national strategy and approach to cybersecurity education, training, and skills in Kenya, which will involve the evaluation of the availability, quality, and uptake of educational and training offerings for various groups of government stakeholders, private sector, and the population at large. This is because there is an urgent need for enhancing cybersecurity education at the national and institutional level, as well as to ensure collaboration between government and industry to ensure the educational investments meet the needs of the cybersecurity environment across all sectors. If approved and with funding, this will lead to the adoption of the Global Cybersecurity Capacity Center's Cybersecurity Capacity Maturity Model for Nations, the CMM, to address this dimension. Lawrence, I'll just start with, maybe you can explain to us what NC3 is, and then jump into your presentation. Thanks.
NC3 is a government body, is a national command center. Yes, I think it is the body that is looking at cybersecurity in Kenya in terms of implementation of various processes that take care of cybersecurity. Can you see my screen?
Yes, we can.
Yeah, thank you very much for the introduction. My colleagues have talked about the digital evidence, and more so McKay has talked about situations whereby you find that you bring cases to court, and these cases flop because of the presentation of digital evidence. So what I'm going to take you through is more or less of a technical presentation coming from an investigator point of view. So I'm coming in as an investigator to help you investigate cases involving digital evidence, and then present that digital evidence to the court as an expert witness. So basically, what you did not say here is that I'm also a consultant for the Cybercrime Program Office at the Council of Europe, and what I do is that I consult in law enforcement training on cybercrime and electronic evidence, and also judicial training on cybercrime and electronic evidence. I'm also an expert witness in court in matters of cybersecurity and digital forensics. And what McKay said is very true, because most of the time when I go to court, and whether I'm on the prosecution side or whether I'm on the defense side, you find that the lawyers are not well equipped with cybercrime, and the questions that they are going to ask you, you find that they are not actually relevant to cybercrime. And sometimes when you find that you are also in the prosecution, Now, that also brings a problem because the prosecutors do not understand how this presenting this electronic evidence is supposed to be in the court of law. So that is myself, what was not talked about me, and I'll just jump on to the presentation directly. Now, here, sorry, just a moment, please. Now, I'm just going to take you through what is digital forensics, because as much as my colleagues have been talking about digital evidence or electronic evidence, how is that electronic evidence produced? That is the process of digital forensics. So when we talk about digital forensics, we are talking about a forensic science. It's a branch of forensic science that is involves methodical application of computer investigation and analysis techniques to gather evidence found in computers and other digital storage media. So here, what I'm trying to say, it is a science itself. The digital forensics is a science itself, and it's a branch of forensic science. And also to note that it involves use of modern technologies and tools to identify, preserve, recover, and analyze and present the digital evidence in a manner that is legally admissible in court. Now, here, when you are a digital forensics investigator, when you are starting your investigation, you have to have that in your mind, at the back of your mind, that this investigation will land you in court. And when it lands you in court, you'll be able to present that evidence in a way that is going to be admissible in court. As my colleagues have said, there's several things that that lawyers do not understand. And when they present this evidence in court, you find that most of it flop because they did not observe some of the things that they're supposed to do. Now, given this, forensic means bringing to court. So if we look at it, is also a branch of forensic science. So which means that when you talk about digital forensics, we are talking about convergence of science and law. So that is the definition of digital forensics. Now, if we talk, when we are talking about digital forensics, it used to be called computer forensics in the 90s. Now, why it was called computer forensics in the 90s? It is because it was only the major devices that were being investigated were computers. And nowadays, with the advancement in technologies and explosion of so many digital devices, we find that we can no longer call it computer forensics. We now call it digital forensics. And now when we talk of digital forensics, we are talking about three branches of digital forensics. We are talking about computer forensics, which is the main forensics that started. And within for computer forensics, we talk about postmortem forensics. In postmortem forensics, all that my colleagues have talked about extracting evidence, we assume that this evidence is going to be taken from computers, and it is going to be taken. Postmortem forensics involves acquiring, processing, and analyzing evidence from this computer when that computer is off, which means that you go to take your evidence, you pick the computer, you get a hard disk, and then you collect your evidence. Sometimes you go to a place where it is not possible to actually pick that computer. Example, if you go to a place and you find that the main source of evidence is a corporate server that is giving service to that organization, or you go to a place where and you find that that computer that you want collect evidence from is actually an industrial control system. You cannot power it off. So in that case, what you do what we call live forensics, which means that you are going to check evidence from that computer while it is on. That is what we call live forensics. Application forensics also involves deriving data, evidence, and traces from applications. For example, if it is a database, now you go and get into that database and try to get evidence from that particular application. Then we have other devices like DVR, routers. All these things, they have data stored in them. So for you to get information from these devices, you need to do what you call you need to image these devices, and this is most of these devices. You find that they have their proprietary operating system and filing system, but the data is within these devices. So you need to have ways of getting data from these devices. The other branch of digital forensics is on mobile, and this is very common nowadays. We find that everybody is using mobile. We use mobile, as the judge had said, you use mobile for some nefarious actions, and you need to do the investigation. So we have a part of digital forensics which is dealing with mobile forensics. The tools that you use to conduct investigation on mobile devices is different from the tools that you use to conduct investigation on computer devices. Then we have also the branch of digital forensics called network forensics. Here is a case where you capture the data as it transmitted across the network, whether it is the local area network, whether it is the mobile network, whether it is the internet. You capture the data as it travels on the internet, and then you analyze that data on the fly. Then you can also do what we call the captured packets forensics, whereby you go to a place and you are told that, yes, this company, you're doing investigation at a certain company. You go to their network, you hook your computer there, and then you get the packets, or you get the files that has recorded the network activity. So that is what we call the captured packets forensics. Now, investigation process of forensics follows a certain methodology, and this methodology, like for what I've put on the screen, this is derived from the ISO 27 ISO 27037. Now, ISO 27037 is a standard, international standard, which is trying to create a baseline for the practice of digital forensics. So it allows you to facilitate the usability of evidence obtained from one jurisdiction to the other by a legal process. Now, this is a standard that was just developed in 2012. However, you find that in each and every country, you have there's a uniform process. There's a uniform methodology of how to conduct investigation, or how to conduct a forensic investigation. So, like this. This model tells us that the first thing that you do when you go to a site, you do what you call identification. After identification, then you do the collection of the evidence, then you do the acquisition of the evidence, then you do the preservation of the evidence, then you analyze the evidence, then you present that evidence in the court of law, or you do a report on your findings. So I'm just going to take you through this process one after the other. Now, when we talk about identification, here is a case. You know, I'm talking from the point of an investigator, a technical investigator, because I'm doing this so that I can help you as a lawyer to go and present this in the court of law. So by the time you go to court, you have proper information about the case, and I'll be beside you to help you. Especially when it comes to cross-examination, because I've done this investigation, I've prepared the report, I come to court, I present it to the court, and then I can be examined by the attorney if it is defense, or if I'm on the prosecution side, and vice versa. So first of all is identification. Now, in the identification process, this involves the search or recognition and documentation of potential digital evidence. Here you are called that there's a crime that has been committed somewhere. So when you go there, you know that you need to do an investigation. And before you do investigation, you need to know what is it that you need to investigate. So this identification process will help the investigator to know which digital data or devices might be involved in the investigation. So it is important to identify what are involved in this crime. Is it a computer? Is it a mobile phone? Is it a laptop? Is it a server? So if you have this, you've identified all the devices and the data, then you know which tools you need to bring in the subsequent steps. So the investigator will also allow the investigator to avoid collecting evidence that are not necessary. So that is the first thing that you do when you go to a site. Now, it is important also here. I have a case whereby a certain not KR, but a revenue authority went to do some raid. And when they went there, these guys told them that, yes, we are using computer, but our data is not actually on these computers. Our data is stored somewhere on the internet or on the cloud. But they still insisted on collecting this computer. So when they collected the computer, you find that they collected devices that had no evidence. So that is why it is important to make sure that you identify the exact devices that has got data or evidence that you are looking for. Now, after identifying that, then you proceed to the collection. In the collection here, you collect the evidence, the devices or the data according to the order of volatility. Now, what do I mean here? What I mean here is that computers have got evidence that are volatile. And if they're volatile, if you handle it, don't handle it properly, then you can miss that evidence. So it is important that you first of all look at the value of that evidence and the volatility, so that you collect the evidence that is volatile first, because that one, if you leave it, it will disappear. So it is important to recognize the volatility of the evidence. Now, the other thing that you need to do is, once you collect them, you transport this to the laboratory for now acquisition and analysis. But what is important here, which also my colleague stressed, is before you do any collection, you must have the legal authority to acquire and collect the evidence, because without this legal authority, it means that whatever you are going to present in the court will be thrown away, because you do not have the power to collect that evidence. So that legal authority is important. I'll give you an example. In 2017, the election in 2017, it was disputed, and then you saw that former Prime Minister Honorable Raila Amolo Odinga came to the TV with another consultant, and then they say that election had been stolen, and they had the evidence to support that. Now, as much as they had the evidence, you find that if they could have gone to court at that particular time, then this evidence was going to be thrown away, because how the question of legality comes in. How did you collect this evidence? So evidence that is collected without the authority, legal authority, cannot actually be admissible in the court of law. So it is another thing that you also need to understand here is that when you're collecting evidence, as I'd said, you find that there are certain machines or systems that you cannot collect, grab and take to the laboratory for analysis and acquisition. So it means that this kind of systems, you need to do what we call live acquisition. You have to collect evidence when those machines are running, and there are tools to help you do that. The other thing also you have to look at, when I go to a scene and I find the computer is on, what do I do? So if you find a computer is powered on, then leave that computer when it is powered on. Do not shut it down. Try to collect evidence which is in the memory. I think those who have been in computing for some times, you remember when the computers came in, when we were using the IBM PC 8086 and MS-DOS, you find that when computer was booting, you could see computer counting the RAM, and it counted the RAM up to 614, and then launches the application. At that point, you can see that if that computer is on, the amount of evidence that can be live in the memory is only 614. But what happens nowadays? You find that a computer has got almost 16 GB of RAM. Now, if you shut that computer off when you go to the scene, you'll find that you lose a lot of information that is actually in the RAM. So it is important that when a computer is on, you must make sure that, first of all, you collect that evidence that is in the RAM, that is the volatile evidence. Because what might be here in the volatile memory or on the RAM? It could be that when you shut this computer on, this computer has got disk encryption. It is encrypted such that when you shut it down, then if you don't have the key, it will not power on again. Sometimes it is protected by password, so that when you shut it down, you'll not be able to actually again power it off on without a password. Without a password. So it is important to note when the computer is on, you leave it on and collect the data which is in the memory before you move to you shut it down. You have to weigh out whether you shut it down. Digital forensics is a new discipline. Sometimes back we were told that when you go to a site and you find the computer on, then you plug it from the socket. And in that case, what happens is that whatever was in the memory is dumped into some kind of a file. Then you can analyze that later. So you have to weigh out whether you have to do that or you have to shut down the computer in the normal way. Then after collecting what you need which has got data, you do what we call now acquisition. Sometimes the process of the data collection and acquisition are taken together, but I just separated them just to explain, because one thing that McKay talked about is about the integrity. Now, it is important that when you are you collected the evidence or the device, do not actually do analysis on the original device. What you do is you have to make a copy of that original device and do your analysis on the copy. And the copy you make a copy through what we call disk imaging. That is, you create a bit stream or a bit by bit copy of the digital evidence, the digital device. Now, this will maintain the integrity. What happens that when you are doing that, you also make sure that you use what we call write blockers. The write blockers will help you when you are writing to the target device. It does not write back to the original device. So write blocker is used to prevent alteration of data while the copying process is going. So acquisition should be done to make sure that the integrity of data is maintained. And how do you ensure that integrity of data is maintained? Is by using what we call hashing algorithm. Or hashing is just a mathematical formula or a mathematical function that you run on the hard disk or the device once you've done the acquisition. So what it does is that it creates what we call hash value or hash value. Now, hash value, we will compare the created hash value with the hash value of the original. And if you compare and they are the same, then you know that the data the data is exactly a replica of the original. So it is important during acquisition to make sure that the integrity of data is maintained. Now, that is just what acquisition does. You see, what the black gadget device there is the write blocker, and I've hooked the hard disk, and this hard disk is being imaged onto another hard disk, which is not shown here. So what this black device will do is that it will make sure that the image, the data, whether this is this is the target, this is the target, the hard disk is the target device, the data that is being copied is not written back to the original device, so that the integrity is maintained. Now, after doing that, you do what we call preservation. Preservation is the process to maintain and safeguard the integrity or the original condition of the potential digital evidence. Now, because digital evidence is very fragile and can be easily altered, damaged, or destroyed just by improper handling. So it is important to preserve this evidence to make sure that when you take it to court, you'll be able to convince the court that this evidence has not been altered in any way. Now, evidence preservation will help in the admissibility in the court of law. Now, in this case, you find that in most cases, this happens with the law enforcement. So with the law enforcement, they must make sure, or if it is a corporate organization, you must make sure that you have stored the evidence in strict access control to protect it from any accidental or deliberate modification, as well as any environment control. So it is important, very much is important to make sure that you preserve the evidence properly. Now, there's something that also my colleague talked about, what we call chain of custody. Now, chain of custody is a legal document. Now, you have to, it refers to the chronological documentation of or paper trail showing the seizure of the evidence, the custody, the control, the transfer and analysis and disposition of the evidence after the court has you presented to court. So it is important to maintain this documentation, because if you go to court and you can not be able to show that this evidence has not been altered in any way, then that evidence will not be actually admissible in court. I have a case in last year where these people had done investigation, and then they brought the evidence to court, and then what they did is that where in the documentation, when I looked at the chain of custody, you know, I looked at the way they collected the evidence. What I found, first of all, the investigator said they used a mobile-like gadget device. I didn't see the name of the device. I didn't see the serial number of the device. I don't know how the device works. So, in fact, when I cast doubt automatically on the evidence that is collected using this mobile-like device. Secondly, when the device was brought as an evidence in court, they later around took it away, saying that they are going to use it to collect more other evidence. So you find that in this case, the chain of custody has already been broken. And when the chain of custody is broken, that evidence loses credibility. So it is important to maintain the chain of custody, and you must make sure that you preserve the evidence from the time it is collected to the time it is presented in the court. And to prove the chain of custody, the investigator who is doing that must testify that the evidence offered in the court is the same evidence that was collected. They must ensure that the evidence offered in the court is the same evidence they were collected or received to the time and date of the evidence that was received and transferred to another agency. Now, this is very important, interesting in the time and date. I had a case again last year, And this case relied on the digital evidence. It was an audio authentication. So when these guys did the video and the audio and banned it on the CD, and I looked at the chain of custody, and I looked at their report, I found that it was not showing how this was done. However, when I looked at the video, the first thing that I noted is on the date and the timestamp. Now, the case was in 2018. And when I looked at the video, I watched the video first before I went to court, I found that it was reading 2014. Then I just told these guys, this case is not normal, because this case is not relevant to the evidence, because the evidence is reading 2014 and the case is 2018. So it is not relevant. And just on that alone, the guy I was representing, I was not the lawyer, but I was an expert witness. The guy was acquitted for several reasons, because of the way the digital evidence was handled. So chain of custody should be initiated at the time you recover the evidence, and it should continue until you go to court and that evidence is presented to court and then returned or destroyed. So it is important to maintain that chain of custody because it is a legal document that needs to accompany the evidence when you go to court, because what it does, it safeguards against the tampering or substitution of evidence, and it makes sure that it can convince the court that nothing has changed. Now, that is just a sample of chain of custody form. There are various ways you can design that. Now, after that, what you do is you do the analysis or the examination. Now, this phase requires the use of appropriate digital forensic tools and method to uncover the digital data. Now, the type of digital forensic tool that you are using depends on the investigation being conducted. Now, remember we talked about computer forensics. So if you're doing computer forensics, you cannot use the same tools that you used for mobile forensics. So they are different. So it depends on, if it was a computer, what tools do you want will use to do that. If it's a mobile forensic, you are doing mobile investigation, what tools will you use to do this? Now, I've just put that link there, which is from NIST. If you go to that link, you'll be able to find different tools that are possible to be used by different for different investigation. Now, there's also, when we talk about these tools, we talk about the standards and best practices to establish the validity and the reliability of digital forensics. So it is important that the tool that you are using has been tested and it is in the mainstream of computer or digital forensics. So to be admissible, the tools and techniques used for digital forensics must be scientifically valid and or proven to provide accurate results. And this is always done by NIST through what we call the testing of these tools. So it is important that you have the right tool for the right work that you are doing. Now, it is also important to note that if you use a tool, then the results must be repeatable. The results must be repeatable if somebody comes and uses the same digital forensic tools with the same data, and then they will be able to arrive at the same results. And it also must be reproducible, in which case, if somebody comes and uses different tools with the same data, then they can be able to arrive at the same results. Then after that, you do your reporting. In this case, you do report to the guy who consulted you. And in most cases, once you do this report, you have to remember that as an investigator, you are going to go to court and you are going to present this report to the court. So the report should be very clear. It should be concise. It should be written in appropriate for the appropriate audience. You don't use technical terms here. because you know you are dealing with lawyers, you're dealing with judges here. You don't lose. You try as an expert witness. You try to educate the court, because the court is going to rely on your report, is going to rely on your expert testimony to make decision. So you have to document the scope and the purpose of the examination. What is it that you are doing? You have to give a detailed description of the media that you examine, whether it was hard disk that you examined, whether it was optical media that you examined, or it's a flash drive. Then you have to document each and every phase that throughout the investigation, and provide description of the evidence that was acquired during the investigation. So your report must be very clear, very concise, and is able to help these guys determine the case, or determine make a decision. If it's a corporate investigation, they can be able to make a decision by using your report. Or if you go to court, then the report is going to help the court determine the case. So this just I've just put some aspect of good reports. A good report achieves the purpose of answering questions that were set out in the mandate for the investigators. It is designed to meet the needs of the decision maker. A good report also, a decision maker must rely on the facts that were presented in the report. Also, the facts must be based on the evidence in the file. It must be clear and written in a neutral language, so that the decision maker and other readers will be able to understand it. Don't use your technical language in the report writing. Then it should also be concise and must convey the necessary information. Sorry. Now, my colleagues also talked about what we call the characteristics of digital evidence. Now, one thing that you need to understand is when you are bringing evidence to court, first it has to be relevant. It has to be relevant to the case that it claims to present. Because this is what I told you, that last year the evidence was brought to court, and when I looked at the video evidence, I found that the video evidence was reading 2014 while the case is 2018. That actually makes it not be relevant, invalidates the evidence. It must be authentic, showing that it is the original evidence that was collected. So authentic means that it is showing that the original evidence is what it says it is. So how do you make sure that the evidence is authentic? There are ways to make sure that that authenticity of evidence is maintained. It must be reliable to be trusted as truthful. Reliability is shown by clear and broken chain of custody, which means that if your chain of custody is which is a legal document, is very clear, it shows that it is unbroken. There's no way that somebody can poke holes on your chain of custody. Then the court will be able to rely on that evidence as and trust it as truthful. It must maintain the evidential integrity. That is, it must be proof that it has not been altered in any way. Now, and this is why I was talking about, do not work on the original evidence. Always make a copy so that you preserve the original evidence. Because if you interfere with the original evidence, then you go to court and the other party says that now we need this same device because you want to conduct our own investigation. Then already you've interfered with the evidence. You've interfered with the integrity of evidence. So it is important to make a copy of that evidence of that device and work on the copy, not the original. Now, the evidence must also be credible. Credibility of evidence, we know that it has to be make sure that the person who is doing the investigation, and this is also very important because one way to demonstrate that digital evidence is reliable is by showing that it was collected in a valid manner. There was a legal authority to collect that evidence. that it was collected using a scientific way in according to acceptable standard. And then the person who was also collecting the evidence, who was analyzing the evidence, who is the investigator, must also testify about his forensic credential and training they possess, the procedures and the process they employed, the tools that they used to collect the evidence and analyze the evidence, and the method by which the evidence was preserved in preparation for court hearing. So that will ensure credibility, because you find that somebody goes and collects evidence and is not qualified when is asked by the court that where is your paper, so to show that you've studied this field of forensics. If you don't have that, means that the evidence that you are presenting in the court is also not really credible. Now, before you see, the forensic digital forensics just came up the other day. So before that, we had what we call the ACPO principles. The ACPO just means the Association of Chief Police Officers, which these guys developed some 4 principles that you can apply on the digital evidence. Now, first principle says that no action taken by law enforcement agency, persons employed within those agencies or their agents should change the evidence, the data which is subsequently relied upon in court. Which means this principle just means that when you are doing the analysis, do not work on the original evidence, because you work on the copy and preserve the integrity of the original evidence, so that in case there's something, you can fall back to the original. Then the number 2 says that in circumstances where a person finds it necessary to access original data, that person must be competent to do so and be able to give explanation explaining relevance of and the implication of their action. Here, what it says that as number 1 says that you should.
Lawrence, sorry to interrupt. We'll just need you to wrap up, because we're running out of time. So if you could just finalize on the principles, then we can take Q&A. Thank you.
Yes. In circumstances, this means that when you don't, the number 1 says that do not work on the original, work on the image or the copy. Now, in circumstances that copy is not available, and you are forced to work on the original data, then you must be capable of explaining that what you did on the original data and the implication of that, your action on the original data. And that is why it is important for somebody who is doing this to be qualified to do that. Now, the 3rd principle is about the audit trail, which means that an audit trail or other record of all processes applied to digital evidence should be created and preserved, so that an independent third party should be able to examine those processes and achieve the same result. We talked about repeatability, we talked about reproducible. So that one is self-explanatory. You can go to court and the opposite side says that, no, we want the same device to do our investigation. So you should be able to do that audit trail to make sure that things moved well. Then the person in charge of investigation has the overall responsibility to ensuring that the law and this principle are adhered to. Yeah, I think that is all from me, and thank you very much.
Thank you for the comprehensive presentation. It's quite interesting to hear the perspectives on the other side. So we'll quickly wrap up and move on to the Q&A session. We have had insights from the bench, the bar, and the technical resources who are also the experts. So I'll quickly run through the questions. Our presenters have had visibility on them, but for the benefit of the attendees, I'll quickly whiz through the questions and then pass them off to the presenters. So the first question is to Judge Wallace from Simeon. He asks, the fragility of digital evidence is critical in the prosecution of crimes, particularly cyber crimes. Can you share some, I'll limit to 1, experience in admitting such evidence? Secondly, to Judge Wallace again, is from Tony. And he asks that due to the nature of digital technology and communications, there are several challenges caused by jurisdiction from different states as well as different countries. How do you handle these challenges? For example, could Uber be sued in California for damages, yet the criminal case was in Maryland? I'm not sure whether there can be criminal damages, but you will speak to that. The third question is to Judge Wallace again, from Nakili. She asks, or he asks, is a judicial officer allowed to challenge the admissibility of electronic evidence when the issue is not raised in the pleadings? A question for Maggie for the East Africa Law Society from Simeon. He asks, is it possible for the ELS to propose and award CPD or CLE points for advocates who participated in this webinar in their respective society? John asks to any panelist, cyber criminals are increasingly using bots to commit cybercrimes. For example, a hacker in China hacks a computer in Kenya, then uses the computer in Kenya to hack a bank server in the US. In this case, who carries responsibility when the original attacker cannot be traced? Is it the owner of the compromised computer in Kenya? I think, Lawrence, you'd be well placed to answer that. For all the panelists, which will be the last one and the closing question with closing remarks, is around emerging technology. So as we're all aware, technology keeps changing, and just before we catch up, especially as legal professionals, we've moved on to the next thing. So currently we're hearing the big buzzwords around big data, data analytics, cloud computing, which John alluded to, and cloud computing, which Lawrence also spoke to, where information and data is in the cloud. So as much as you go into an office and unplug the computers, you won't have that information or that evidence. Blockchain and distributed ledgers, when you speak about hashing, 5G for cell towers, you know. So how do you, as experts, foresee the future in terms of evidence collection in light of digital evidence? So there's also a question for Robert. Just to share your perspective in terms of practice and being on both sides of the legal practice aisle. So both being prosecutor side and also the defense counsel side. What do you think are the important things that any practitioner on this call on either side of the divide should take note of in summary? So I'll quickly hand it over to Judge Wallace to start, then we can move to Robert and then finalize with Lawrence. And then I'll hand it over to David to give us closing remarks on behalf of AGA.
Okay, so with regard to some of the questions that were directed to me in particular, I'm not going to take them in the same order because I think it will make more sense if I discuss them in this order. Can a judge challenge the admissibility of electronic evidence even if it's not challenged by one of the parties? Yes, in theory, in the United States, a judge can do that. I generally refrain from doing that because my role as a judge is to be a neutral mediator. And there may in fact be reasons why one side has not challenged the admissibility of evidence. They may find that even though it's a little bit harmful to them, that once that evidence comes in, there's a lot of helpful information for them. So they may be setting a trap, for example, and I don't think it's my role as a judge to spring that trap. This is, after all, an adversarial relationship and or adversarial system. And the theory is that when the two adversaries challenge, then we'll get close to the truth, close to justice. And if one side is not challenging, they probably have a good reason for it. And so I don't interject myself. And when I teach new judges, I often will tell them the same thing. Of course, if it is becoming very obvious that one side, the lawyer, is simply incapable of or not very competent, and we're running the risk of a miscarriage of justice, then yes, I will jump in, but not often will I do that. With regard to admissibility, in addition, particularly if it's in the United States, we have both juries that hear some types of cases and judges that hear others. I know in Kenya, judges hear everything. if we are the fact finder, what I tell judges is rule based on the the rules of evidence as to whether evidence is admissible, but often admit it and then give it the weight that you think it deserves. So if there's some questions in your mind about whether the chain of custody was valid or whatever, I would admit the evidence, but then when I'm making my decision, say, it's admitted, but I don't find that it's persuasive because I have all these questions about the integrity of the information, for example. That then brings us back to the first question, the fragility of digital evidence. My experience in dealing with those admissibility issues, my experience has been that generally that evidence is not challenged because if there's a qualified expert who's made the analysis and there's a good chain of custody, then there really is no legitimate challenge. The Robert can correct me, but my recollection of the Amaro case, the teacher with the pornography on the computer, is that those problems arose because the police investigator was inexperienced. He had, a purchased software program that said, I attach this program to the computer, and this is what it kicks out, and this is what it says. And when an experienced investigator, a digital investigator, forensic investigator, looked at the computer, they found that that wasn't in fact the case, that some evidence, I guess one of the things that I recall was that the original testimony of the detective was that a button was red because it had been pushed to access a particular website on the computer. And when they investigated, they found out that was not the case. The button was actually green, and that particular website had never been accessed. And so an experienced person came in and said that that's not the case. Digital evidence, yes, is fragile, as all evidence is. So I think we get back to my end note is avoid the technological heebie-jeebies. Yes, somebody can fake and alter digital evidence just like they can a document. And in the old days, we'd have documents when I first started with carbon paper, and then we had copiers, and people could change the document. But you use the same analysis generally, I think, in determining which do you believe. If the document has been changed and the font looks different than the rest of the document, that might alert you that there's been a change. The same would be true with the digital evidence. One of the advantages of digital evidence is there's the metadata, the data behind the data. That is, what you look at a document, but the metadata shows every time that document was accessed and if changes were made and when they were made and where they were made, who they were made by. So one of the good things about computer technology, digital technology, is that it has the ability to store vast amount of information. And so you have that metadata to examine as well. So yes, it's fragile, but it's not as fragile as people fear, I think. And the fragility may be changed. Lawrence talked a bit about that. And when he talked about, the question is the analysis reproducible? My experience has been that when you put the computer experts together, they reach the same conclusion because they're scientists. And they use the scientific method and their professional analyses to come to their conclusions. And so I've often said, put the geeks together and they'll solve this problem as to what the legitimate evidence is. Can evidence be destroyed? Yes, in theory. But remember again that when you delete something, you're not deleting it. You're just telling the computer that space where it is stored is available for use in the future if you need it. So it's not like you're erasing something or setting it through a shredder. You're just making the space on the hard drive of that computer available to be used again if necessary. So it can still be recovered. My understanding, my younger brother is an FBI agent, and he supervises a cybercrime unit that's attached to the CIA. So he doesn't tell me much about what he does. And I said, well, can you recover erased data? And he goes, yeah. He said, officially, we say that if it's been erased 7 times, we can still recover it. He said, unofficially, you can count on, we can probably recover it if it's been erased more. But he said, publicly, we haven't answered that. So yes, digital evidence is fragile, but it can also be recovered. And I'm familiar with a case where some of that evidence is, yes, they wiped their computer, but what they didn't do is wipe it of their search and downloading of the software to wipe their computer. So the existence that the defendant had searched for wiping software, had downloaded that, was very strong evidence of a guilty mind, somebody who was trying to cover up and get rid of evidence. So it continues to exist, and it's fragile, but it's not that fragile. And my experience has been that most people do not challenge the admissibility of digital evidence unless they have an expert report that strongly shows that there's a question about its validity. Then there was a question about a jurisdiction. So the United States, I'm sure as you know, is comprised of 50 states. Each one has its own jurisdiction. Generally, what we do is we say that for lawsuits, companies or people or companies can be sued where they're headquartered, where they're domiciled, or where they regularly carry on a business. So Uber, for example, can pretty much be sued in any state in the United States. Uber, since I brought it up in that case, they were very helpful in solving that crime of that rape in the Westang Pierre case. But there have been allegations that they're negligent in hiring and retaining drivers. And so they have sex offenders, known sex offenders who are drivers, and that may lead to a rape. They can be sued anywhere, regardless of where the rape occurred. They can be sued in any jurisdiction where they operate regularly. The same is there's a more constriction in criminal aspects. It would be very hard, I think, to find that Uber is criminally responsible and to bring criminal charges for them. But usually that happens, jurisdiction in a criminal context, in the United States at least, is where the major act, the actus reus, occurred. There may be overlap where, a kidnapping may start in one state and carry over into a second state, or we also have the state and the federal, and so there may be overlap. But generally, it's where most of the crime has occurred, where the major portion of the crime has occurred, is where jurisdiction lies. The other thing with regard to jurisdiction is states and countries have agreements as to jurisdiction. And so you have mutual legal aid agreements between countries for the sharing of information, the obtaining of information, and the like. And one of my former law clerks actually works for the Justice Department doing just that, dealing with governments of other countries in getting digital evidence or evidence from that country to be used in prosecutions here, and vice versa, getting evidence here to be used in prosecutions elsewhere. So those cover several of them. And then I guess, why don't I save the last question that was broad to the future, and we can all discuss that, or would you rather I discuss that now?
Later is fine.
Okay, thank you.
Robert?
Thank you. Mine is with regards to having been a prosecutor and now a defense attorney. How do I manage? One, as a prosecutor, you have a duty to court. As a defense attorney, you have a duty to court as an officer of court. Now, when it comes to being a defense attorney, one thing that I learned when I was a prosecutor is the aspect of working in teams. When we founded the Anti-Corruption Division of the High Court, we used to have what we call prosecution-led investigations, whereby you get Lawrence, who is a forensic expert. He joins the prosecutors to manage a case before the DPP sanctions it. So much so that when the matter is taken to court, at the plea-taking stage, you are ready to proceed with the case. That is the best thing that I learned from prosecution. Now, when I joined the defense, I had to ensure that in our law firm, we handle cases in teams. We get a file, each and every person is given a task to do research. We hire experts. We investigate as they investigate. That's what we do in our office. Then secondly, we mastered the art of saying that our duty is to ensure that our client gets off the hook within the law, not at all costs, within the law. What do? We take the prosecution on its run for its money or its activities. What do I mean? The burden of proof has never shifted to the defendant or the accused person. Now, our duty when we are defending is to ensure that we raise reasonable doubts at all material times. For example, Lawrence talked about the principal fruits of a poisonous tree. Illegally obtained evidence, is it admissible? Now, for us, if we have been given the disclosures, the best things we look for into the prosecution's case is, have they proved each and every element of the crime that they have preferred against our client? Because you do know, as I do, that failure to prove any essential ingredient in a criminal matter, the accused person or the defendant must be acquitted. That's what we do. Then, lastly, it is our duty to ensure that justice is done. Justice can be done either by way of an acquittal or by way of a conviction. Now, where we discover that we have been retained to defend this accused person or defendant for the case of the US, that's how they term them, we always encourage them to enter into what we call plea bargain agreements. You can call it negotiated justice. So much so that there is a win-win situation. But where we find that prosecution has done a miserable job, and as far as investigations are concerned, and as far as the evidence that they intend to rely on is concerned, we defend up to the last bit. Because we have one theory in our office that when your enemy is making mistakes, do not interfere. I thank you so much.
Thank you, Robert. I'll pass it on to Maggie and or David around CPD points.
Well, unfortunately, Maggie has paused her video. She will have been best to provide an answer for this. What I know is most law societies will normally ask us to pay for each person that attended a webinar, and this being a free one, it becomes quite difficult for us unless individual attendees actually pay as per the demands of the law societies, the national level law societies. What we've been doing in the past is we've been issuing certificates of participation. so that you can be able to show that you actually took part in a forensic evidence training for lawyers. That has worked in the past, especially for physical trainings. We are trying to wrap our heads around providing CPD, but then that will have the logistics of having as paid. For LSK, I know it's about 1,000 Kenya shillings per individual. That's about $10 for them to be able to grant CPD points for training of this nature. So we will work around it, and we will want to get back to the attendees on this webinar. You can write to us through the emails that were there on the application document, the document you used to register. Then we can follow it up with the relevant national bar associations, and we will be able to provide CPDs, because a 2-hour session like this should have CPDs. So
okay, thanks, David. Just quickly, Lawrence, maybe you can just respond to the last question around hacking over the cloud, where a Chinese person does it in Kenya, and then I'll pass it on to David to just quickly conclude and give us the closing remarks, as we are way past time.
Yeah, basically, when it comes to hacking through the surface or surface web, that is the surface internet, that is not difficult to investigate. And what I can say is what Judge Welles said is that you bring the technical geeks together and to do the investigation. So investigating such a hack is not as difficult as it could be if you are talking about the dark web. Because if you look at the botnet, you find that it has a structure. It has got a hierarchical structure with the command and control at the top, and then you have the bots at the bottom. Now, when you're doing the investigation, what you look at is you look at how the traffic is moving, and there are quite a number of tools to do that. And also, recently there's been a framework to investigate the bots. So it is not something that is difficult, because when you bring the right experienced investigator to do that, they will be able to uncover the command and control guy who is controlling these bots by just studying the bot's behavior, by detecting the bots at the lower level. So it is not something that is difficult. You can remember in 2007, the Russians attacked Estonia and brought down the internet, where no service was being done could happen because over the internet, because Estonia is quite networked and everything is done over the internet. And when this happened, is the Russians they claimed that Estonia was actually attacked by the whole world, because what they did is that they hacked into these computers, they made them zombies or bots, and then they used them to attack Estonia. But still, when Estonia reached out to NATO, they were able to investigate and find out that it was actually Russia. So it is not something that is difficult. When that happens, we'll be able to investigate and find out where is the original source of attack. Thank you.
Can I just follow up briefly on that last question, where there was talking about, is it the owner of the compromised computer in Kenya who may be responsible if they can't find who's responsible? Again, avoid the technological heebie-jeebies. Think of it in another context. If my car had been stolen while I was here in my office and was used in a bank robbery, would I be responsible for that bank robbery? I think not. And I think the same is true. If my computer is hacked without my knowledge, am I responsible for the behavior of somebody else who used my computer just like they used my car? I think not. And I think you need to reorient yourself to the analogy of the non-digital world to see whether that would still apply. Avoid saying, oh my goodness, it's computers, it's digital, and so things are different. No, the same general rules apply. That would be my analysis on that. Did you want to address the, you had talked about futures, and 5G and big data and things like that. Do you want to do that, or have we just run out of time?
We have run out of time, but unless you keep it to 140 characters, literally a tweet, and then David just close it off.
That's okay. I'm a lawyer. I can't keep anything to short little tweets.
So I proceed to finalize the session. John? Okay. On behalf of the East Africa Law Society, AGA Africa, I would like to thank Judge Wallace, Mr. Lawrence Dinga, John O'Carl, Robert McKay, Ms. Bangi Baingana, a member of our governing council, who has stayed with us through the entire meeting, for giving our members a really excellent training on digital forensics. This will really impact many people. Me personally, I've been taking a few notes. This is very important, especially for those in actual practice, like Robert McKay. And we will want to proceed with other trainings in future of this nature. We hope COVID ends and we can be able to mix them up, physical and online trainings of this nature. So thank you so much to our presenters and panelists. To members who have been with us throughout this session, I think we still have more than 60 on board. At some point we went up to 120. Thank you so much for staying with us through the session. It's our hope that you learned a lot and that you will be joining us in our final session under this series next week. That is Wednesday 22nd. And many of our future trainings, both under the Institute and under the ELS itself. And to our partners, AGA Africa, thank you so much for the work you put in to make sure this particular webinar goes on board, including bringing in Judge Wallace. We really thank you for taking your time to join us through this session.
My pleasure.
With these remarks, I have seen Maggie back. She's my boss. I would like her to officially say it is finished.
Oh, I just unmuted myself. Thank you so much, David. I had stepped away a few minutes ago. That job is really easy. It's just to declare the meeting officially closed. Thank you so much.
Thank you.